Speak with Mr. McGrath.
Well, thank you so much for being here. To describe forfeiture is to condemn it. It's a pretty easy thing to advocate for reform because it is contrary to principles of innocence until proven guilty and separation of powers. Let me explain. So my agenda today is to show you the design perspectives and incentives, and I'll watch the clock, and you can stop me if I'm going too far into history. And so let's dive into the design, the perspective, and the incentives. So forfeiture is a two-track system. I'm driving in Kalamazoo, I'm driving in Ann Arbor, I am driving in Lansing, and I get stopped by law enforcement. My person enters the criminal justice system. My car and my cash enter the civil system. And in Michigan, as in most states, these two things are independent. What happens in one does not influence what happens in the other. This idea of a civil forfeiture is a legal fiction, that somehow my car and my cash can be found guilty or liable in and of themselves for the activities in which they were involved in. But this is modern civil forfeiture today. Two tracks. The police and prosecutors have different roles. The police are in the seizure business. The police, so taking that example of my driving in Kalamazoo, the police are responsible for stopping me and seizing property when they have probable cause that I've committed a crime and the assets are part of the crime. By contrast, prosecutors are in forfeiture, and forfeiture is very different from seizure. It happens in courts, and the state legislature has certain responsibilities, and it can set the burden of proof, whether it's on the property owner or whether it's on the state, and they can set the standards of proof. Standards could be probable cause, preponderance of the evidence, clear and convincing evidence, or beyond a reasonable doubt. But the key message on this slide for you is that cops do one thing, prosecutors do another. And across the country, the reforms that are going on only focus on the work, and the reforms here only focus on the work of prosecutors. Let's go to the next slide and talk about how does a defense attorney look at this two-track system. Well, a defense attorney is a bit schizophrenic because when the suspect enters the criminal justice system, that suspect has certain constitutional rights. Among them is a presumption of innocence, which means that the government has the burden to prove the crime, and it's a high standard of proof beyond a reasonable doubt. But that schizophrenia, or that bipolar view of the world, is very different when it comes to the property. Because one, if the defense attorney is a public defender, he can't help me, or he can't help my property, rather. He's prohibited from entering civil court. He can only help me in criminal. And that raises the question, well, do I go out and hire a defense attorney who is not a public defender? And that raises the question of, well, how much is my car worth? How much is the cash that has been seized worth? If only $800 has been seized, then I rationally just walk away and don't spend $3,000 hiring an attorney. So that's the defense attorney's perspective. Let's look at property owners. The first property owner is the suspect. This is me driving in Kalamazoo. When it comes to the criminal justice system, I must be found guilty beyond a reasonable doubt. When it comes to my car, the government has the burden to prove that my car is an instrument of the crime and the cash are the proceeds of the crime. And here in Michigan, that burden on the government is preponderance of the evidence, is 51%. One of the bills that is being considered by the legislature is to raise that standard of proof from preponderance 51% to clear and convincing 67%. So that's the suspect. But what about Mrs. McGrath, the innocent owner claimant? My wife, my relatives, my neighbor, the bank who has lent me money, the rent-a-car company who I've rented the car from. They are innocent owner claimants. They're different from me, and they actually have to overcome a presumption. When it comes to their claims, they have to go into court and prove the negative. My wife has to prove that she did not consent and she did not know about my criminal activity in Kalamazoo, so therefore she should get the car back. So those are the different players. You have different roles, you have different worldviews. From a legal perspective, on track one, the criminal track, I have certain constitutional rights, including the second one, the Gideon right to an attorney. I have the right to a speedy trial. By contrast, my car does not get Mirandized. My cash does not have a right to an attorney, and none of my property has a right to a speedy trial. But what's the real issue? Beyond all this structure, beyond all these different roles, the real issue is that the state of Michigan, like all but 9 other states, has decided, this is a decision of past legislators, to let law enforcement supplement its budget with forfeiture proceeds. So, in Michigan, law enforcement forfeiture proceeds, when done under state law, the budgets of law enforcement can be supplemented by every penny that has been seized and forfeited. And when collaborating with the federal government, up to 80% can come back to the city of Kalamazoo if I am litigated under federal law. Let's take a look at how one chief of policeman from Columbia, Missouri, looks at this incentive.
There's some limitations on it. You know, it's actually there's not really on the forfeiture stuff. We just usually base it on something that would be nice to have that we can't get in the budget, for instance. So, you know, we try not to use it for things that we need to depend on, you know, because we need to go ahead and have those purchased. But it's kind of like pennies from heaven, you know, it gets you a toy or something that you need, is the way we typically look at it.
I have met police chiefs who share the sentiment but lack the candor. And this is an effective way for law enforcement to supplement budgets on issues of equipment or on overtime. And so law enforcement does have incentives in this regard. How are we doing on time? Okay, so let's go now, just a quick history on how we got here. Blame the English. As someone whose last name begins with MC, I can tell you that that's a good explanation for everything that is bad in this country. Forfeiture made sense to the King of England and British navigational acts in the 17th century. And the reason it made sense is that the king could not arrest the person, could not gain personal jurisdiction over the shipper who was violating tariff or navigational acts. So in lieu of gaining personal jurisdiction, the king created this legal fiction that the ship and the cargo can be held responsible for the failures to pay tariffs and other shipping fees. The key here, the key concept, why this is justified, or was justified, because it was a doctrine of in absentia, that you couldn't get control over, you couldn't get personal jurisdiction over the violator of the law, so in lieu of that, you took control over the ship and the cargo. So, we talked about that, the practical necessities. The United States adopted this because the federal government funded itself initially through tariffs, and so it adopted that. And every NASCAR fan will tell you of scenes about forfeiture when the police seize the car as well as the alcohol. But it wasn't until the Comprehensive Drug Act of 1970, which started with proceeds going into the general fund of the federal government, but then later changed in 1984 to allow the Justice Department to receive these funds and supplement its own budgets. States quickly followed. So this is a case that my firm has done in Fraser, Michigan. It is not involving state forfeiture law, it involves federal forfeiture law. It involves our client who was accused of a crime of repeatedly depositing money of less than $10,000 so as not to trigger reporting requirements when he went up to the bank. What this video doesn't tell you is that the tellers at the bank said, please don't come in with more than $10,000. It's a heck of a lot of paperwork when you do. So here's our client, Mr. Deco from Fraser. About what's going on in Michigan, tell you about how forfeiture law currently is being applied in Michigan. Dan?
Well, hi, everybody. When I came to the ACLU as a young attorney, I guess I'm still a young attorney, but I was even younger then, and right before I arrived, my boss at the time sent me a little synopsis of one of the first cases I'd be working on, and it was a forfeiture case, and I couldn't believe. I read the facts of this case, and I thought that can't be right. But we litigated this case for several years. It turned out that those facts were exactly right, and they really are an example of our broken system of forfeiture here in Michigan. In fact, anyone who has been ensnared in the forfeiture system here in Michigan will tell you that it's in desperate need of reform. And really why we're here today is because Lansing is the place to get that done, and hopefully that's well on its way to happening. But that case that I told you about was the Cade raid case. And some of you from the Detroit area may be familiar with it. The Cade is an acronym. CAID stands for Contemporary Art Institute of Detroit. The Cade was having a fundraising event for young adults in the Detroit area. They were serving alcohol at their event. They apparently didn't have a special license that you're supposed to get, even as a nonprofit, to serve alcohol at a fundraiser. And the Detroit police decided that because that alcohol was being served without a permit, they would raid the entire event, the entire Art Institute, in their commando-style SWAT team gear with, guns drawn, the big guns, wearing all black, some of them wearing masks. There were 30 or more officers screaming at everyone to get down on the ground. And these are young people, some of whom from Detroit, some of whom not, but they want to support the art scene in Detroit. And unbeknownst to them, they are at an event where something technically illegal is going on. They find themselves face down on the ground. Some of them were outdoors in the back of the place, and they were. It had recently rained. They were face down in the mud with police officers' boots on their heads. And at the end of all of this, what did it come down to? They were all told that their cars, if they had driven to the Cade, were being seized under forfeiture laws. And everyone there were over 100 people at the Cade, and 50 of them had driven cars. And all 50 of those cars were taken into custody by the Detroit Police Department. The people, of course, were not taken into custody. It was the cars that the police were after. And the police said, you were at the scene of a crime. Remember, there was allegedly some sort of alcohol being served without the permit that was required. You were at the scene of a crime. Your cars were used to get you to the scene of the crime, as cars are used to get you anywhere. And so, therefore, your cars are instrumentalities of this crime, and we can take them under state forfeiture law, and those cars are ours now. You no longer are entitled to these cars. And they said, now, if you want to challenge this ridiculous thing that we just did in court, you're free to. Of course, you'd probably need a lawyer to do that competently. And then you would schedule a hearing in Wayne County Circuit Court in downtown Detroit. That hearing would probably be scheduled for several months out down the road. At which point, when you get to the hearing, you can try to argue that that car should not have been seized by the police, and you can try to get it back. Now, if you win that argument, congratulations, you get a really dusty old car back that you haven't seen in months. If you lose that argument, of course, the car is gone forever. You no longer have that car. So the police said, we'll give you, we'll offer you a compromise in this situation. If you pay us $1,000, we will give you your car back. So what are the real choices here? It's pay $1,000 to get your car back, which they call a compromise. We call a ransom, because that's essentially what it is. Or you go and get ensnared in this mess of a forfeiture system and probably don't come out much better in the end anyway. And so most of them, obviously, people need their cars to go to work, to go to school, that sort of thing. And most of them did end up paying. Some of them, if their car was very old, is worth less than $1,000, they're not gonna pay for it. But nonetheless, they don't have a car anymore. And so what this really is about is the Detroit Police Department. They can go and raid one of these events on a weekend night or whatever. If there are lots of cars there, they seize them all. If it's 50 and they get $1,000 per car, that's $50,000 for the night, and maybe they can do that the next night or the next weekend too. So this is a revenue-raising device. There's no legitimate control and oversight over it, because remember, if you really want to get a court to take a look at this, you have to wait a long time. It's this whole big thing. And so the police know at exactly what level to set that ransom, $1,000, so that people just say, well, forget it, I'll just pay it and I'll get my car back. And so that's the problem. That's essentially what's going on. And it's not just happening in Detroit. That's a pretty outrageous example. But that kind of seizure by law enforcement and abuse of the forfeiture system of people who are completely innocent, is what goes on every day across the state, across the country, and it's really what needs to be changed. Now, the $1,000 ransom that I just mentioned is similar to another concept which we have in forfeiture law, which is called a bond requirement. We just represented an individual up in northern Michigan who had just gotten a fairly sizable insurance settlement because she was involved in a car accident and had been injured. And she had just cashed the check from the insurance settlement. There was some sort of tip that she had drugs in her house. The police came, and not only did they raid her house for looking for drugs, but while they were there, they came across the cash settlement from her case. I believe it was about $18,000, and they said, "We're just going to take this. This is ours now," like the Cade raid. This money is ours now. If you want to challenge this, if you want to say, this money had nothing to do with drugs, you can't just take my money, all of the things that you and I would think are rational arguments, you can do that. You just schedule a court hearing, and you'll go before the judge, and you probably want to hire a lawyer, but you go before the judge and you explain what the situation is. We'll get that taken care of sometime in the next few months. Oh, and if you want to schedule a court hearing, you need to pay what's called a bond in order to get the court hearing. And a bond means if you deposit the bond and you win the case, you get your bond back. If you lose the case, your bond goes away. Okay, so how much is the bond? Well, it's 10% of whatever the money is that we took, or the value of whatever it was we took. So if we took $18,000, you have to post a bond of $1,800 just to have the hearing. Well, this woman, unfortunately, she was unemployed. She's destitute. She had just gotten this settlement, but they took it all. So what happens when the law enforcement takes all of your money, everything you own, and then says, "Oh, if you want to challenge the fact that we've taken all of our money, all of your money, you have to post a bond in order to challenge that"? Well, of course, it's impossible. It's the perfect catch-22. And so for people who are not of means, or people who have some means but not much, are ensnared in this kind of a system that is totally unfair, provides no oversight, and punishes you for being poor, for not being learned in the law, and for daring to challenge the fact that the law enforcement officials have just come in and basically stolen your property, your cash, what have you. And so this is another aspect of this bond requirement, this idea that you can't get justice or due process or a fair hearing until you pay more money on top of the money that's already been taken from you. This bond requirement has to go as well. And so hopefully Representative Irwin and his fine colleagues will be working on these things over this session and maybe over the next few years, because these examples are just going to keep piling up over and over again. People are going to be ensnared in this system that provides no justice, no fairness, and it's got to change. So thanks.
Well, thank you for that setup. These gentlemen did a great job of explaining what's wrong here in America and what's wrong here in Michigan, how we've been severed from our due process rights, how you're not innocent until proven guilty, and how we need to change that. I think they've made a real good case, and I've seen the case as well in my work here in Lansing. We get calls into my office probably because of the work I've been doing on these issues from all over the state, from people who've been raided and people who are experiencing the same sorts of problems and frustrations that Mr. Korobkin just explained to us. Folks who are saying, "I've been raided multiple times by my local police. I'm a medical marijuana patient. They keep coming in, and then they take all my stuff. They wait for me to rebuild, and they come and raid me again." I just heard from a gentleman last week in Bay City who said he's been raided 5 times. over the course of the last several years and has always been under compliance. But every time that he seeks to challenge these forfeitures, his local police are, threatening him that it's just going to get worse for him and that they're going to report him to CPS and have his children taken away. And we've seen this happen here in the state of Michigan. We've seen people be on the receiving end of retribution from law enforcement, and that gives me an opportunity to thank the McGrath Center for having this forum and for the work that the McGrath Center has been doing on this issue. And I think all of us who've been watching this issue have followed the story of Mr. Kowalski down in Southwest Michigan, who, when he made noise about how his rights were being trampled, and when the McGrath Center took up that case and explained to the citizens of this state what was going on in this case, he was promptly charged, and it looks certainly like there was retribution by law enforcement for speaking out. So it's important that we do have folks who are willing to stand up and say what's right is right and to fight for changes in these laws. And that gives me an opportunity to also recognize my colleague, Representative Gary Glenn, here in the front row. He's another one of the reps that's participating in the package of bills to reform forfeiture law here in Michigan, and I appreciate him joining us. This is a real opportunity for a confluence of philosophies. I think it was mentioned earlier that maybe it's a little strange to have someone like myself up here at a McGrath Center event, but I think it actually just speaks to the power of this argument and the power of the confluence of philosophies you're getting with people from both sides of the political spectrum coming together and saying, wait a second, this isn't right. We have to fix this. We have to do something about it. And so what are we doing? Since I've been in Lansing, I've been introducing legislation to simply require that in order for assets to be taken, that an individual must be convicted. To me, that seems like the straightest, most complete solution to this problem, right? Here we have the government visiting sanctions upon people without convicting them. That's un-American. Let's stop it. Now, unfortunately, despite the fact that I've introduced that legislation multiple times now, we haven't been able to get a hearing on it. It hasn't moved forward. But I think what happened this year, what changed this year, is that with the new leadership in the House, Speaker Kevin Cotter came along, and with the new membership in his caucus, they put out a 70-point action plan at the beginning of the year. And one of those action plan points was to reform civil asset forfeiture law. And when I saw that, I thought maybe there's a real opportunity for us all to work together and get something done here. And that's exactly what's happened. We've got members from both parties that have introduced legislation. There's a suite of bills. Just give you the numbers real quick. They're 4504, 4505, 4506, 4507, 4508, and 4499. And what these bills do together are a number of important things. The first thing is that there are a few bills that deal with reporting requirements. Now, Michigan has pretty lax rules in terms of how law enforcement agencies and prosecutors have to report assets they've taken from citizens. In last year's report that rolled up at the state police level, I think it was about $24 million that were taken from Michigan citizens that was reported. But there's really nothing that requires them to report. There are agencies that don't report. And also, the report isn't very helpful, right? It doesn't tell us whether the individuals were convicted. It doesn't tell us whether the individuals were ever charged with a crime or what crime that was, right? Because those of us who have been working on this issue for a long time who've been saying this is un-American, we need to stop this, we come forward and we tell the story of the Cade raid, or we tell the story of a cancer patient who's been raided multiple times and is in compliance with our medical marijuana laws. But then when these issues come forward, law enforcement steps forward and our attorney general steps forward and they say, no, we need these laws to go after dangerous crack dealers that are selling in front of the elementary school, right? And because our reporting requirements are so weak, we don't really have a good idea of which of those stories is real, right? I know which stories I hear, but there's two very different stories about how this tool is used. And when we get these reporting bills hopefully passed, we're going to get a stream of information. They'll be able to tell us, what kind of cases originated these forfeitures? Was it the crack dealer, or was it the medical marijuana patient? Was it a blind pig at a art gallery, or was it something more sinister? Right, because I have a sense of what the state of reality is and where these funds are coming from, but we need to get a better sense of it. And it's not just to get better information; it's also to motivate good behavior on behalf of our law enforcement agencies. Right, I think a good corollary is to think about how the body cams have changed law enforcement behavior in some areas. So the community that went first with the body cams and went completely to a policy of requiring them on all their officers was Rialto, California. And they did a look back after doing that for a couple of years, and they realized that the incidence of unpleasant interactions between citizens and police dropped 80%, right? Now, I think that part of that, and we could talk a lot about body cameras and the concerns about privacy and how we get it right. I think those are important issues. But the important kernel of this story, I think, is that just the presence of the cameras changed behavior. Just the sense that someone's watching changed behavior. And if we get these reporting bills passed, I think we're going to have police agencies exercising a little more caution and a little better discretion about which cases that they want to push forward to forfeiture, right? And because none of our police agencies want to be the gentleman from Missouri who was profiled on your video there. So I think the reporting requirements aren't just about paperwork. They're actually meaningful requirements that will improve behavior. We also have a couple of bills, and Representative Glenn has one of these bills on increasing the standard of proof, increasing the government's burden of proof from where it is now a preponderance of the evidence, as Mr. McGrath said, 51%, up to clear and convincing evidence. So in other words, if these reforms were to pass and the government were to try to exact a sanction against a citizen, that sanction being taking their property and their assets, the government would have to actually prove to a clear and convincing standard that those assets were involved in some sort of illegal activity rather than a situation we have now where it's a he said, she said, and where the courts usually come down in those cases. We also have legislation that I've introduced that seeks to end some of the more insidious practices around push-offs and buybacks. And Mr. Korobkin explained the situation in Wayne County, which is that if your car is taken in one of these situations, like at the Cade raid or after a reverse buy, so after the police put an agent out on the street to sell to people, and then when they sell drugs to someone, then they apprehend the individual. So when they're engaging in one of those reverse buys, what ends up happening is, the police put the citizen in this trick bag where they say basically, you can pay us now or you can pay a lot more to maybe get your assets back later. I have a bill that's meant to really stop that behavior by creating a presumption in law that if you have a small amount of marijuana, that is simple possession, it's not transacting, and therefore you couldn't be caught in this snare of civil asset forfeiture. So just basically stipulating that small amounts of possession of marijuana would not be subject to asset forfeiture. We also have another bill in the package dealing with the bonding requirements, just eliminating the bonding requirements so that that process whereby individuals have to pony up money to have access to their constitutional rights is ended. So we've got, I think, a really strong package of reforms that are coming forward. Those reforms have had hearings in the House Judiciary Committee last week and then again yesterday. I'm very hopeful that those bills are going to be voted on favorably out of the House. And I'm hopeful because the bills are sponsored partly by the chair of the Judiciary Committee, Clint Kesto, who's been great to work with on these bills, and our Speaker, Kevin Cotter, made it a part of the action plan, and also recently was published in an opinion piece in the Detroit News saying that we need reform in these areas. So I feel that we're in a good direction. We've got some good reforms that have been introduced, and I'm hopeful to be working on these with all my colleagues. I think we're poised for some positive change here in Michigan, and I want to thank all of you for being here and helping move that along. If there's one thing I could ask you to do, it would be to call your senators. This bill, these bills, I think, are going to be on the way to the state Senate, and they need to hear from you. They need to hear from you that this is an important issue. They need to hear from you that you understand that this is un-American and that our rights are being abrogated, and that we need some reform in this area. So call your senators, and thanks for being here.
Thank you so much to all our panelists for providing all that distinct perspective that you each have. You all have cards by your chair. If you want to fill out one of these cards and ask a question, please feel free to do so. Yep, just raise your hand and we'll be collecting those cards and be asking as many as we can. Please write as legibly as possible so that we can read those and get those answered. We do have a study here. It's near the top of this table about over-criminalization. And this is similar to this type of issue here, where there are a lot of things in Michigan that are illegal, but they probably shouldn't be. If you read the study, there are various examples, and one of the examples in there is that there's a law in the books that you cannot dance to the national anthem. I know my kids are probably guilty of that. I don't dance well, but if I did, I'm sure I've probably broken that law. Also, there was a law one time on the books in Michigan that unlicensed dogs, if you had an unlicensed dog, you didn't have the tags, you didn't have the license for them, the sheriff's department was supposed to go to your house, pick up that unlicensed dog, and kill that dog. And it was illegal to adopt that dog out, take it to a shelter. It had to be taken by the sheriff's department and killed. Most sheriff's departments said, we don't want to do that. And eventually, it took a while, but it finally had gotten changed. So more common sense is getting into this. One of the questions that I have as we start out, probably Lee would be good to start off with this. What are other states doing on this, and have there been any reform recently about civil asset forfeiture?
Michigan is not alone. 26 states are currently or have in this legislative session considered forfeiture reform. The two big ones that have enacted it are New Mexico and Montana. Let me tell you about New Mexico. New Mexico has ended civil forfeiture, completely repealed it. So unlike my hypothetical of driving in Kalamazoo, if I'm driving in Albuquerque and I get stopped, my person goes into the criminal justice system, and so does my car, so does my cash in the same system. And so in New Mexico, I first must be convicted of a crime, and then the same jury, the same judge decide whether the car and the cash are the instruments and proceeds of the crime for which I have been convicted. One of the advantages of that is that because it is in the criminal justice system, I have the right under Gideon to be represented by counsel. And so does my car and my cash. And so unlike a two-track system, New Mexico has now followed North Carolina, and with just a one-track system. In Montana, they have kept the two-track systems, but they have required a conviction or an admission of guilt in the criminal justice system as a prerequisite to forfeiture in the civil system.